folks, and welcome back to Contract Law. This is the video series on vitiating factors, and this is video 2 in the sub-series on mistake. In the first video, we had a look at the general foundational concepts in relation to mistake, and we particularly had a little look at equity and the kinds of equitable remedies that might be provided. And now what I would like to do is jump into common mistake. First of the three kinds of mistake, three main kinds. The first thing to note about common mistake is a terminology issue. Where you say you have a case of common mistake, when you are using this as a legal term of art, what you mean is that there has been one mistake that has been made and both parties have made it. One mistake is made, both parties have made the same mistake. You'll see why I labour that point in just a moment. Where the mistake is fundamental and it goes to the heart of the contract, like I said in the last video series, in the last video, if it's sufficiently severe to go to the essence of the contract, such that the contract without that feature is essentially different, then the common law would say, well, unfortunately, the contract is void. So the contract will be void at common law for common mistake. If the common law result is that your argument is successful and the contract is void, equity is just going to follow the law. So that contract will be void at common law and in equity. Okay, equity is not going to race in and try and revive the contract from the proverbial dead, as it were. It's alive! It's alive! It's alive! It will just follow the common law. Okay. Now, there's two fairly old and reliable categories of case law here, and they deal with different subject matters. First is res extincta, which means, I'll leave Latin again, the thing has perished, and res sua, which is the thing was already his. And we will have a look at res extincta now. And the big case that you need to know for res extincta is Couturier and Hasty. And in this case, we had a buyer and seller of a cargo of corn. Both of them believed it to be en route to the UK from Salonika. Unfortunately, it had become very hot and the corn had overheated, and they very quickly offloaded it and sold it in Tunis. And so at the time of contracting, essentially what the buyer was trying to buy had perished. It was res extincta, and there was nothing to be bought. And so therefore the contract was void at common law. A far more hilarious case is McRae and Commonwealth Disposals Commission, and in this case the CDC advertised for tenders to actually go and salvage this oil tanker that was supposedly lying on Juramond Reef, 100 miles north of Samurai. The McRae outfit won the tender, very eagerly go out and expect to find an oil tanker, and in fact, not only is there no oil tanker, there is no Juramond Reef. Can you imagine their surprise? Obviously, they seek redress from the CDC. The CDC tries to disclaim any liability for this monumental mistake on the grounds of mistake, not surprisingly. And they said that we were both mistaken. It was a case of common mistake, one mistake made, but there was a tanker and it was lying in this position in this reef. As you can imagine, it didn't fly. The court said, nice argument, but unfortunately you cannot rely on your own fault where a mistake is your own fault, you can't rely on it to back out of the contract. And obviously, of the two parties, the CDC was in the position to know whether indeed there was a Juramond Reef or a tanker on Juramond Reef, and so therefore they couldn't succeed in common mistake. So that is race extinctor. The next one is race sewer, and this one means, as I said, the thing was already his or hers. And the case here is Cooper and Phibbs. And I guess you're wondering, well, how on earth could you contract and purchase or obtain something that was already yours? Well, in this case, we had a fishery. It's meant to be a photo of an old-time fishery. We had a fishery that was at issue, and the plaintiff actually took a lease of this fishery. Some years previously, his uncle had said that he'd owned the fishery, and when his uncle passed, the plaintiff decided to lease the fishery from the uncle's children, his cousins. And what he didn't actually know was that the fishery had been left to him by bequest. So in actual fact, the cousins didn't have anything to lease to him. It was already his. And this is a classic kind of scenario for race sewer. So at common law, that contract was void. The other circumstance, no rocket science to that one, is there? So the other issue is if your circumstances are not a case of race extinctor and not a case of race sewer, and the common law would already dictate that the contract should be held valid, is there any room for equity to come in and save the day and still provide some equitable remedies? There are, as I said, remedies available, refusal of specific performance or possibly rectification. The main litigation has been around plaintiffs seeking rescission of a contract in equity, even though common law might potentially say that the contract should be valid. And here there has been an ebb and flow in the case law that has left us in a bit of a pickle, because so far as Australia is concerned, we don't have any clear authority on this issue yet. The first case that we need to look at on this issue is Bell and Lever Brothers. And in this case, we had a bunch of naughty directors who actually could have been fired without paying them any money. However, neither the directors nor the company knew this, and so the company just wanted to get rid of them and decided to give them a payout and send them on their way. Well, that was all very good, but the company then found out that they could actually go ahead and terminate the contracts for all these directors without paying them anything. And so they ran off to court and tried to get the court to sort it all out for them, saying that there was a common mistake and therefore the contracts under which they were paid termination payments should be held void. Per Lord Atkin, as I've got there on the slide, both parties must have assumed the existence of some quality which makes the thing without the quality essentially different from the thing as it was believed to be. This gets back to my comments in video 1. It's got to be something pretty darn important, pretty essential, that goes to the root of the contract, and it really is quite a different contract without this thing, whatever has been mistaken. And in that case, the court said, well, hang on a minute, look at what's happened here. You sought to terminate by contract these directors, and under that contract you paid them some money. The outcome was that you had severed the employment relationship. whether you've paid the money to do that or whether you haven't, at the end of the day, that contract achieves exactly the same thing, which is you're severing the employment relationship, the director's relationship with the company. And therefore, it's not essentially different, not void at common law. Typical, fairly hard-nosed common law point of view, but one that makes, the line of common law decisions very reliable, I guess, and makes the certainty of contracting, I guess, optimal, doesn't it? Then we have the case that upset the apple cart, so to speak, Soleil and Butcher. Good old Lord Denning, one of Denning's most favourite and famous legacies. What we had in this case was a landlord that had been reliant on his tenant for doing a number of things for him, for surveying and also advising on the rent that was payable. Because in those days, you can see the age of the case, a number of buildings in London and in Britain generally were subject to the Rent Restriction Acts, which controlled the amount of rent that was payable for flats following World War II, when flats were at a premium, and they didn't want landlords charging, hideous amounts of rent for people in those very austere times. The tenant actually told his landlord that the Rent Restriction Act didn't apply, and therefore the landlord could charge substantially more than under the Act. They then both found out that the Rent Restriction Act did apply, so essentially the landlord had been technically overcharging the rent for that particular flat. And so the tenant ran off to court and sought a declaration that he could get the cheaper rent for the entire duration of a 7-year lease that was stretching out in front of them. He was a little bit cheeky, frankly admitted that he was taking advantage of the mistake to get this cheaper rent. The real unfortunate part of this case was that the landlord actually could have, under the Rent Restriction Act, could have charged the higher rent that was being charged because this flat had been substantially refurbished. All that the landlord would have had to have done is served a particular notice prior to signing up the lease and setting out, this is refurbished and so on, and he could have charged the higher rent. But because they both thought the Act didn't apply, he never served the notice, and so he was in a bit of a pickle, this landlord. Obviously, Lord Denning felt for this poor chap, and surprise, surprise, notwithstanding that the lease agreement would have been valid at common law, it was held voidable in equity. Therefore, the landlord could rescind the lease, and didn't quite finish there. He had to actually offer the tenant the choice between continuing on at a higher rent or vacating the premises. So that's Soleil and Butcher. The case that came after this is the Great Peace case, and this is the one that's really had people quite divided, and courts in Australia also are quite divided on this issue as to whether it should be applied here. We had a ship called the Cape Providence that suffered some structural damage, and so the owners hired a company to provide a tug and a vessel to stand by in case things went very wrong and the crew needed rescuing. They got a hold of the Great Peace. They thought that the Great Peace was only about 12 hours away, so they said, great, can we please hire you for your minimum 5-day charter? Hurry up and get there as fast as you can. We want you to stand by in case you need to do anything, rescue anybody. But then it transpired that the Great Peace was in fact 39 hours away, not 12 hours away. Now, when Tavleris found this out, they purported to cancel the contract, not surprisingly, when people's lives are at stake. They hired another ship that was closer, and the Great Peace then owner decided to sue for the 5-day minimum charter. Tavleris argued, not surprisingly, there had been a common mistake. Unfortunately for Tavleris, the court held that the contract was valid at common law, The shades of the Bell and Leader brothers case here, in that it was held that the contract was not impossible to perform, and the contract for a ship that was 39 hours away was not essentially different to a contract for a ship that was only 12 hours away. So, like I said, shades of Bell and Leader brothers. Well, you've terminated the directors. That's the outcome at the end of the day. Whether you could have paid them money or not, neither here nor there. Something similar here. And they actually held that Soleil and Butcher was wrongly decided, and that equity had no place in stepping in circumstances like this where the common law would say that the contract was valid. Have a read of it, see what you think. Our courts in Australia have gone both ways. Some courts, state courts that is, have followed the Soleil approach. Some have followed the Great Peace approach. The High Court's yet to definitively conclude. So I'll leave you to ponder that one at your leisure. So that's common mistake. And now we need to have a look at mutual mistake. Mutual mistake is really super duper simple as compared to either common mistake or unilateral, actually. The unfortunate thing about the case law here is that a lot of it's older case law, and unfortunately a lot of the judges are not precise with their technical legal terms of art, and they start calling mutual mistakes common mistakes. Sometimes you'll read cases of common mistake and they use the term mutual mistake, which is then really confusing and easy for law students to make a mistake when they're talking about terms of art. So what you need to think of, and the way I remember this, is that mutual mistake applies to multiple mistakes. Many mistakes made mutually. I use an alliteration to remember that mutual mistake applies to mistakes where the parties each make their own different mistake, okay? And the main case that you need to think of here is Raffles and Wicklehouse. The thing with mutual mistake is it will never succeed if the court can make an objective interpretation of the contract. If they can do that and they can work out, well, one or other of the parties actually got it right, then the argument for mutual mistake will not succeed. However, if one of the parties runs off to court and says, hang on a minute, there's a case of mutual mistake here, I thought X, Joe Bloggs thought Y, and the court looks at it and they honestly can't make out, after looking at all the facts of the case, they honestly can't bring to bear an objective interpretation of what the contract should mean, then the contract will be void at common law for mutual mistake. And that's exactly what happened in the Raffles case. So there was a hiring of a ship, ex-Peerless. So the ship was called Peerless, sailing out from Bombay, ex-Peerless from Bombay. However, there was one Peerless ship that was due to sail in the October and one that was due to sail in the December. But it wasn't stated in the contract which Peerless was to be carrying this cargo. And so, unfortunately, because the court couldn't make heads nor tails of the contract either, it was void for mutual mistake. So many mistakes made mutually. Rather simple, easy peasy, that one, isn't it? So that's mutual mistake. Unilateral mistake is a little bit more complex, and this is where there is only one party that's mistaken, obviously, because it's unilateral. The law, again, will provide no relief. This is at common law unless the mistake is fundamental. So there are three categories of unilateral mistake in the case law here. Firstly, unilateral mistake as to identity, unilateral mistake as to terms, and there's another funny little branch of case law that deals with unilateral mistake as to the nature of the contract signed. And we'll have a look at these three different strands of case law. First one is mistaken identity. And the way that you deal with mistaken identity really depends on whether the parties were dealing face-to-face, we call that inter presentes, or whether you're dealing at a distance from them, for example, by writing. So dealings other than face-to-face. If you raise a successful argument of unilateral mistake of identity, again, at common law, the contract is going to be void. Dealing with circumstances where you're not face-to-face first, because that's the easiest. Generally speaking, courts have been a little bit more receptive to arguments here because you haven't got the person right in front of you, so you haven't got that immediacy of checking out whether or not the person is actually the person that you have intended to deal with. Okay, you need to establish that the offer was only intended for party A, and that A's identity was in fact vitally important to your client. The offeror must have taken reasonable steps to verify A's identity, and the person, not persona, the person actually contracted with must have been aware, this is the rogue B that's impersonating A, must have been aware or should have been aware of the offeror's true intentions. Cundy and Lindsay is the case law there. Just a crook who wrote a letter and signed it, signed his name, which was Glenn Calm, signed it to look like Blenkeron, and Blenkeron was a reputable dealer in goods. So successful argument there, the contract was void at common law. Inter presentes is a bit more exciting. For unilateral mistake of identity inter presentes, there is actually a presumption that you intend to deal with the person in front of you. So the law basically puts up a little roadblock here and says, you know what, it would just be too easy for parties to be able to back out of a contract and just plead, oh, sorry, unilateral mistake of identity. I actually thought I was dealing with A, but I ended up dealing with B. Please let me out of this contract. Not so simple. If, as I said before, the party's right in front of you, you have every opportunity to check their identity and to actually look after your own interests. And so what you have to do to be successful here is rebut the presumption that the court says, well, sorry, buddy, you intended to deal with whoever's in front of you. So you need to show that you didn't intend to deal with the party in front of you and that all reasonable steps were taken to verify the identity. There's a trilogy of cases here. The Ingram and Little case is another Denning case that caused many academics some consternation, shall we say. But Lewis and Avery is the one that kind of has had most consensus of opinion that it was quite a reasonable outcome. In that case, one of those lovely little British mini-looking cars that I've got pictured on the right there was at issue, and the owner was approached by the rogue, who called himself Richard Green. Richard Green was a very famous actor in the 70s, and he said, "Oh, you're Richard Green," and he produced what looked like an official-looking pass from Pinewood Studios. So he was convinced that this rogue was the famous Richard Green who was about to buy his little Mini. So he let the car go with the logbooks and everything, all the kit and caboodle go with this rogue in exchange for a cheque that obviously bounced. And the rogue on-sold the vehicle. The question was this going to be void for mistaken identity inter presentes? What had enough been done to rebut the presumption? The court said no. Just checking the rogue's own dummied up identity card was not sufficient to look after your own interests. Unfortunately for you, the mistake as to identity had no remedy at common law. The contract was still valid, and therefore, because the contract was valid, the title passed from the original owner to the rogue, and from the rogue to the third party, the poor third party at the end of the line. And so their interests were protected. As I said, a sensible outcome, I think, at common law there. So that is unilateral mistake as to identity inter presentes. And the other one to think about is mistake as to terms. Here, obviously, the court doesn't take a subjective approach, it takes an objective approach, and that's pretty much the same for 99% of questions in contract law. The court will take an objective approach. So if it looks like a contract has been outwardly formed and the court can interpret it such that it functions okay, it will likely be valid at common law. However, there is this hanging question mark about whether or not it could be voidable in equity. And Taylor and Johnson was the case here. I'll leave you to flesh it out for yourself in your readings, but very briefly, the parties contracted to buy and sell 10 acres for $15,000. Now, Mrs. Johnson thought that this contract was for $15,000 per acre, about 10 acres, so she thought she was getting about $150,000. In fact, it was worth about $195,000, so she thought even then she was selling cheap. However, in this option agreement, Taylor knew that it said that it was $15,000 all up. He did a couple of fairly underhanded things there. He knew that she didn't have her glasses, so she couldn't read this option contract. So he deliberately refrained from mentioning the price again at this meeting where she signed. And then she says, "Oh, can I take a copy home?" And he says, "Oh, sorry, I don't have a copy to give you to take home," when he actually did. Now, notwithstanding that this kind of mistake was simply a mistake as to a term, and it wasn't fundamental to the operation of the contract, it would have been valid at common law. However, here the court does refer to the old common mistake case of Solé and Butcher, Denning's case. And they said, look, we're going to take a similar kind of approach here in unilateral mistake as to terms, and we are going to say that this mistake rendered the contract voidable in equity. So dear old Mrs. Johnson would actually rescind. So again, I think a sensible outcome. The elements, you have to show that the other party is aware that there's circumstances exist that can show that the other party was suffering under this serious mistake about the content or subject matter of a term, and then they deliberately set out to ensure the first party doesn't become aware. Classic sharp practice, what we call sharp practice, enlivens equity's jurisdiction and allows equitable remedies to be offered. So that is Taylor and Johnson. Dear old Mrs. Johnson, don't forget your glasses when you're going to sign a contract. The last kind of unilateral mistake is a funny old category of cases. We call them non-spectrum. That's another Latin phrase, yang, for it is not my deed. It's not my deed. This was covered in Chapter 10 of law, so you should be across it already. No need to labour it. Simply where the plaintiff belongs to a particular class of vulnerable people, for example, unable to read or illiteracy, and they can't understand the purport of the document. And the document is radically different in character or effect from what was intended. There was no carelessness, so none of that McRae kind of fault that could be pointed at the person that has signed in error. At least as against, when you're up against the other party being a completely innocent person, you have to show a lack of carelessness. And if you can show those things, you may well have the court declare the contract void for non-spectrum. Have a look at the Galley and Lee case there. So that is unilateral mistake. And that is the vitiating factor of mistake. Thanks for watching, guys. As I always say, if you have any queries or questions, please don't hesitate to contact me, email me, tweet me, Teams me, any old how, just get in contact and we can sort it out. Other than that, I look forward to chatting with you next video series, and bye for now.